Hey everyone, welcome back to the Hot Seat SA, where we break down the facts, the drama, and the truth behind South Africa's biggest court cases. Today, we're reacting to something that caught a lot of people off guard, a moment in the Senzo Meyiwa trial, where the judge seems to misrepresent what the forensic DNA expert actually said in court. Let's roll the footage and unpack this together, piece by piece.
Actually, let me read it to you from what they are saying. That is now in what exhibit now? Exhibit X in bracket 12, my lord.
Yeah, no.
Exhibit
I'm
X
listening.
in bracket 12.
Yeah.
And that is page 4 of 5. And this is why the scientists from the Forensic Science Laboratory in South Africa, it's internationally recognized, for that matter. And this is what they are saying. From the results in table 1, that is where the comparison was done.
Manje kumele utafundeka lapho mana nombukiso lapho ka X bese ngaphathi kwamafutha bracket 12 kukhasi lesineke kukhasi lesihlanu ke athi lolo hlelo mhlawumbe le report cwaningo lolo ke loqhamuka kubantu bezomvelo abeze science waqhamuka lapho ke science forensic laboratory.
I can make the following findings. This is Captain MP Maseta that is writing this.
Athi lo mbhalo bhalo warrant officer Captain Maseta athi lokhu awuthola kulandelayo.
Paragraph 4.1.
Lapho paragraph 4.1.
The donors of the following reference sample were excluded as the donors of the DNA on the swab, in parentheses 1, and the head, in parentheses B, in bracket, presumable high friction area.
Athi benza ucwaningo malana nohlelo ama DNA abakade belithathile ke kumuntu futhi babeqhathanisa phakathi kwesigqoko lesi kade benaso ke.
And those donors are MZ Mapisa.
Athi lapho ke umuntu kade khona MZ Mapisa,
BS Ntanzi,
Mncube,
Untulifiso Kuhle, Sibia MS.
no Sibia MS.
Let me simplify this. He simply says here, from his analysis, the samples that were obtained from the donors, which are the names of the people that I've read here, could not be matched with the DNA that was found in the head, as well as the swab. These are the swabs that were found in the doors and the bedroom areas and stuff like that. But primarily, none of the names of the people that I've read here could their DNA be matched with the DNA profile that was found in the heads.
Listen closely. This is Advocate Mnisi quoting the actual forensic DNA report. No opinions, just what's on record. There it is, excluded. That means the DNA on that hat does not belong to any of the 5 accused. In forensic terms, an exclusion is not debatable. It's definitive. But now, watch what happens later when the judge gives his summary of this evidence.
Is it?
Yes.
I mean, it's like fingerprints. That's for our wait.
Oh, I'm sorry, madam. I'm
full
sorry.
understanding.
I'm sorry.
A forensic expert in fingerprints comes and that's for fingerprints. And then he gets 5 matching prints or profiles of prints. But because the scientific attribute of saying Ratha Mokgwatheng's fingerprints were found at the scene, there must be at least 7 points of identification. But if they find 6 points of identification or 5 points of identification, it doesn't mean Ratha Mokgwatheng wasn't there. It just means those prints which were lifted there, because they don't tally up to 7, they are inconclusive. That's the scientific language they use. Am I right, sir? They are inconclusive. They are inconclusive.
Wait, hold up. Did you catch that? The judge just said the results were inconclusive, but that's not what the expert said. In forensic science, there's a world of difference between excluded and inconclusive. Let's break this down. So when the expert says all 5 accused were excluded, that means their DNA simply isn't on that hat, full stop. The judge rewording that as inconclusive is either a mistake or something more serious. This raises huge questions. Is the court trying to leave the door open where the evidence has actually shut it? And if so, why? Because if a judge misunderstands or misrepresents expert testimony, it affects how we understand justice being done.
The donors of the following reference sample were excluded as the donors of the DNA on the swab, in parentheses 1, and the head, in parentheses B, in bracket, presumable high friction area.
athi benza ucwaningo malana nohlelo lwama-DNA abakade belithathile ke kumuntu futhi babeqhathanisa phakathi kwesigqoko lesi kade benaso ke.
And those donors are MZ Mapisa,
athi lapho ke umuntu kade khona MZ Maphisa,
BS Ntanzi,
uBS Ntanzi,
Mncube,
Mncube,
Mtulifiso Kuhle,
Ntulifiso Kuhle,
Sibiya MS.
noSibiya MS.
What do you think? Was the judge just mistaken, or does this show a deeper issue in how evidence is handled in this trial? Drop your thoughts in the comments, like and subscribe for more unfiltered breakdowns from the Hot Seat Essay, because sometimes the truth isn't in the judgment, it's in the details.
And if you found this video eye-opening, don't just scroll away. Smash that like button, share it, and subscribe for more hard-hitting breakdowns. This is the Hot Seat, signing off. Stay vigilant, folks.